discussion, we are dealing with the last week of land, and basically we shall be looking at expropriated properties and natural resources. So I believe that this is a very brief work. So let us see what the workshop is all about. But in case you want a discussion group that will help you answer the past papers, I already have one. Just contact me, and then we can discuss the past papers in our group. So they are saying that in 1972, Asians not holding Uganda citizenships were expelled by the military regime, and their assets taken over by the government to be managed by the Departed Asians Property Custodians Board. A decree was passed to legalize and provide a legal framework to manage the properties. This was the Assets of Departed Asians Act. Later, the Expropriated Properties Act was passed to undo what had been done in 1972 to the extent provided by the law. The effect of the EPA was to undo everything that had been done from 1972 until the passing of the EPA, including expropriation of properties from departed Asians and sale or rent of the properties by the Departed Asians Property Custodian Board. Therefore, this module will explore the permitted and prohibited dealings in these properties, the rights and liabilities that arise upon repossession or other dealing in the properties. The module also deals with conservation of the environment and natural resources. Herein, the aspects considered the environmental concerns or controls that affect the land transaction. These environmental controls relate to issues such as wetlands, lake shores, and river banks, and statutorily regulated, and their relationships to land transactions has to be evaluated. These environment controls are what a legal practitioner considers effectively and conclusively undertake instructions in a transaction affected by the physical planning legal regime. So basically here we shall be looking at Expropriated Properties Act. So I remember in my first term when this topic was introduced, I was asking myself what relevance is this to my legal practice, because I thought in my small understanding that maybe there is no longer property which can be under which is no longer to be expropriated, because I thought in my view that all the properties were expropriated and we don't need to study about these things. But fortunately, there are some still properties which are still subjected to this law. So it's very, very important that you appreciate it. Basically, once you meet one of the properties in practice and you see whether it was properly dealt with according to the Expropriated Properties Act. So basically, you understand that following the coming into the Idi Amin regime in 1971, so Idi Amin regime issued a legal notice which sent all the Asians who were in Uganda to go back home. So most of them, their shops were overtaken, and it really created a lot of bad relationships as far as foreign relations is concerned. So when the NRM came into power, one of the things they had to do was to correct the errors of the previous regimes. So among many other things they did was to look for a way how they can call these people who own their properties and who were chased away, see how they can give them back their properties in a way to develop foreign international relations. So they passed the Expropriated Properties Act, which was basically to handle the way of how the government can recorrect its image by giving back the properties to the Indians. So basically we shall be looking at how was that act now applicable to these Indians. So learning objectives, the week's tasks are enabling identify expropriated properties, comprehend and apply the law on expropriated properties, identify and interpret documents, transactions, and titles affecting or affected by the application of the expropriated properties law, identify the status, the statutory and other restrictions, transactions in protected processes, identify the ethical dilemmas which may rise out of these areas of the law. Workshop 1. The students will explore the permitted and prohibited degrees In expropriated properties, the rights and liabilities that arise upon repossession or other dealings in the properties. Learning outcomes. By the end of this workshop, students should be able to 1. Identify expropriated properties, appropriately interpret the law in respect to expropriated properties, completely render advice in respect to lawful dealings or transactions in expropriated properties, and appreciate ethical dilemmas that may arise in the course of executing instructions relating to expropriated properties and how to deal with them. We have the Constitution, the Assets and of Departed Agents Act, and Expropriated Properties Act. We shall look at the case of Chris Akena Onapa versus Muhammad Hussein Rashid. Justice Sekoko noted that the test for expropriated property is whether it vested in the government so as to fall within the ambit of Section 1 and 2 of the Expropriated Properties Act. So he was trying to describe basically what is an expropriated property in that decision of Chris Akena Onapa versus Muhammad Hussein Rashid, which is going to be one of those things we shall rely on. So let's look at the facts. Naida is a son to the late Ajin Naida, a Ghana of Asian descent who left the country in early February 1976 with his entire family, following the expulsion of all non-citizen Asians by the government of the time. Arab's father owned various properties, all of which, save for the land comprised in LLV 42 plots, 40, 41, and 42 Mbare, which he did not declare at the time of departure. Unfortunately, he died in the United Kingdom in 2013. Prakesh obtained probate over his father's estate in the United Kingdom and has now returned to Uganda. He has received the probate in Uganda and is intent on taking over all his father's properties. The status of the properties is as follows. 1. Land formerly comprised in LRV, Kampala, currently registered in the names of Solomon Musoke as lessee. The lesser Hajj Ibrahim successfully terminated Ajin's lease in January 1982 by re-entry for non-payment of rent, and therefore granted Solomon Musoke a 49-year lease with effect from 1st April 1982. Old Kampala. Solomon replaced the farm structure which were on the land with a modern hospital which is fully operative. So basically you can see that this one was a lease, and this person terminated the lease for non-payment of rent. So here what the Indian can recover could be because now the question would be, was it declared to the custodian board, and was the lease being complied with before time he departed, among others. Then 2 land complies that LLV Mbare was sold by the Departed Agents Properties Custodians Board to Masa Mori in November 1878. Musa Musori also sold it to Musari Wakesa, who operates fish ponds and a large-scale fish processing plant on the land. Juno obtained a certificate of repossession in respect of this land in 1999. So basically we shall look at because when these people left, all the properties were given to the departed custodian boards. So these boards were the ones supposed to deal with the properties of the departed Asians. So whoever wanted the property would deal with the board. So we shall basically look at the powers of the boards, what was supposed to do, and how do you recover from the board. So land comprised in plot 12 Port Bell Road, Naka, was held by Ajun Mudu on a 49-year lease with effect from 1st October 1959. It is developed with a 3-storied building. It's currently used as students hostel by Benson. Benson obtained a lease in respect of that property from the Kampala District Land Board, having earlier been a tenant of the Departed Agents Property Custodian Board. Then we also have land comprised in FLV Sizibwa Road, Nakasero, is registered in the name of Ground Zero Society Limited, which purchased the same in August from Gold Coins Bank of Uganda in exercise of the rights of sale as the mortgages. The loan obtained from the said bank by Ajun Naidu having remained and paid over the years. So one thing you have to understand is the Expropriated Properties Act is one of those laws that over the fixed precedent or a fixed precedent over all other acts. So where there is a Mortgage Act and the Expropriated Properties Act, the Expropriated Properties Act will take precedence, because it was one of the laws. The rationale for that was basically passed to remedy the wrongs of the previous governments. So it basically means that where the Expropriated Properties Act is contravening any other act, then you are supposed to treat this one as conclusive. Then we have land comprising LLV Lord Mbare is currently registered in the name of Ibrahim Muzungu, which certificate of purchase was issued on October 1999, respect of all properties except for the property and Mbare in respect of which had obtained certificate of repossession in 1999. So the certificate of repossession is also provided for under the Act, but very important things to understand. One is what are expropriated properties, because when you look at section 2 of the Act, section 2 of the Act defines, section 2 of the Act defines, section 1 of the Act defines define that property to mean any property which was transferred to the departed agent's custodian board acquired by the government under the Properties and Business Decree. So any property which was transferred to the departed agent's property custodian board is deemed to be expropriated property. Then also section 1 defines a departed agent to mean any agent who left Uganda on or after the 9th day of August 1972. Then also it defines the former owner to mean any person who was a registered proprietor of any property and was either expelled or forced free from Uganda during the military regime. Effect of transactions on expropriated properties, section 2, subsection 2 of the Act is the effect that any purchases, transfer and grants or any dealings of whatever kind in such property or business are nullified. So all dealings therein are nullified. Whether it was a mortgage, a lease, by section 2, subsection 2, all dealings on that property are nullified. Then section 2, subsection 2, where any property was at the time of its expropriation held under a lease, any tenancy, the same shall be deemed to have continued and enforced until dealt with in accordance with the Act. So you can see now section 2 also says all the leases did not expire by the fact that the people were sent away. Then we shall look at the certificate of repossession, repossession certificate under section 4. Any former owner of the property vested in the government may apply to the Minister for Repossession of Property within 90 days. So any person can apply to repossess the property within 90 days, and if it's of certificate of repossession in section 7, certificate issued under section 5 shall be sufficient authority for the register of titles to transfer title to the new joint venture company or former owner. So they are conclusive evidence of ownership. Procedure for repossession or application. Application for and grant of certificate of repossession, section 4, and regulations 10, and notice before repossession, among others. So basically, each task 1 is supposed to what pertinent issues would guide you in addressing the rights of the parties in each of the above scenarios. So we are supposed to look at each properties and advise whether that property is already available or not. But basically, when you look at section 2, subsection 2, you find that most of those properties the transactions were done what were nullified by the Act. So we shall analyze each property and come to a conclusion to whether that one is either available or not. Then 3, what advice would you give to each of the parties in regard to their respective legal positions and remedies, if any, available to them? We shall see a lot of remedies available to the parties, including compensation, including missing profits, including damages. Because if you had also paid your money, then you are supposed to also recover by compensation, by vacant possession, miscellaneous profits, and then notification of transactions and repossession. So those are some of the remedies we shall be looking at. Then 3, in the event that you are instructed to pursue the remedies you have identified into above, what are the pertinent steps you will take to obtain the said remedies on your client's behalf? So the remedies basically where we have damages and compensation. That means we shall have to lodge a plaint, because all those ones, damages, vacant possession, then we'll proceed by suing. That's how we would be in position to get those damages. So basically that's what we shall be looking at in workshop 1. Basically just read the Expropriated Properties Act and regulations therein, because they are not much. Then once you are done, you will be able to understand the law as far as the expropriated properties are concerned. Also, among others, you can challenge the powers of any officer other than the minister. You can also challenge the powers of the minister. So that's what we shall be looking at as far as workshop 1 is concerned. So workshop 2, we are doing with the natural resources. The workshops deal with conservation of environmental and natural resources therein. The aspects considered are the environmental concerns or controls that affect the land transaction. These environmental controls relate to issues such as wetlands, lake shores, and river banks. As still required at their relationship to land transactions has to be evaluated. These environmental controls are what a legal practitioner considers effectively and conclusively undertake instructions in a transaction affected by the physical planning legal regime. So by the end of this workshop, students should be able to correctly interpret the law on natural resources and the environment, as well as related legal regimes such as the laws planning and public health, competent advice on protection and conservation of the environmental and natural resources, identify the ethical dilemmas which may arise out of these areas of the law. So we have the Constitution, the National Environment Act, Public Health Act, among others cases. Motinyakana versus Nema. This person had constructed in a wetland, and Nema later removed his house. So when you read it, you will find that he had challenged that the act was contravening his right to property, but the court stated that if you construct in Nema in a wetland, then Nema has rights to remove that house. We also have Water and Environment Media Network Limited versus Nema, and Hoima Sugar Limited Consolidated High Court, Advocates Coalition for Development and versus Anthony General. So these ones are environmental cases. Part 1. Due to the bad fishing habits of the actors in the fishery industry in Uganda, who'd file fish by fishing and selling underage fish, His Excellency the President of Uganda has taken the Minister of Lands, Housing and Urban Development to remind him, advise before he can act aggressively and proactively by completely removing fishing activity from the lands of locals and put it into the hands of investors. His Excellency the President of Uganda has already identified a major investor known as Noreb Fishery Company, a Russian company, whom he intends to get a major concession to undertake oil fishing on Lake Victoria. His Excellency the President of Uganda also intends to grant 200-year leases to Noreb Fishery Company in order to facilitate their activities over the northern shore of Lake Victoria. As a legal officer of the Ministry of Lands, Housing and Urban Development, you have been tasked by your line minister to advise on the procedure and formalities by which the leases should be granted to the Noreb Fish Company, render the requisite advice. So basically here what you have to understand is when you look at Article 237 and 244, you find that all these resources, lakes and water are held by the government in trusts of the citizens. So where the government has to lease them, that basically means they have to go into the proper procedure by carrying out the impact assessment of the project and the likely impact it will have the environment, getting confirmation from the necessary authorities like NEMA, among others, to find out that this project is not going to affect the environment. So after having got all those necessary approvals from NEMA, having carried out the environmental impact assessment, then you can proceed and get lease the project. But basically here what you have to understand is you have to look at the role of NEMA, the Physical Planning Act, among others, as these are the ones which are going to be giving you the powers to advise on whether they can give out that project or not, in light of the fact that Article 2372 provides that the government shall hold in trust all the natural resources on behalf of the state, including minerals. So basically that's how we shall be looking at. Then part 2, your client Mr. Mustafa Nzina recently purchased 60 acres of land at Namanve, Mukono district, comprised in LLV. It is also believed that part of this land has some rare earth metals. The lease was expressly granted for purposes of commercial enterprise. Mr. Mustafa intends to use as a hazardous waste landfill to service the industries in the area at a fee. Your client has asked you to advise him on the above physical planning considerations that must address in preparation of the said project. Render the requisite advice. So basically here we shall be looking at the disposal management, because when you look at the NEMA Act, it basically shows us the necessary approvals you need to get if you're going to use any property or maybe dispose of the wastes in the property. You must have to get some standards and also permission from the NEMA. And also we also have to carry out the environmental impact assessment on the project to see its impact and how basically can we stop the negative impact on the environment. So basically those are some of the things we'll be looking at: waste management, right to a clean environment, environmental impact assessment, physical planning committee, to come up with the advice in task 2. Part 3, Sauda Mirungi is before you. She informed that she is the registered proprietor of the land located at Chanodobrook, Kampala, and is a neighbor to Come and Relax Hotel Limited. The hotel usually has parties and weddings reception at its compound. She further tells you that during such occasions and all parties, the hotel plays very loud music. The sound emissions from the hotel has become unbearable. She then tells you that she personally measured the degrees of the noise emanating from the hotel and discovered that the noise rose over the afternoon constantly up to 100 decibels. This exercise and enough noise levels have affected the affairs. She tells you that she has made numerous complaints to the officials of the regulatory authorities, requesting them to cease this disturbance, but the same have ignored the complaints. Hajat says she is heavily affected by the noise, yet this place is designated for residential purposes. Whenever Hajat engages the hotel owners, they deny the allegations and they insist that they do comply with the memorandum of understanding. So advise Hajat Sauda Mirungi. So basically here we have the case of I think Nyakerezi, Dr. Nyakerezi versus I think Bgonji Secondary School, where there was a pit latrine which was emitting a very strong smell, and he sued under private nuisance. So basically here we shall also be having the same cause of action, nuisances, smell, sounds, among others, but also under the Environmental Act there are some sound emissions which are regulated. So we shall also have to look at that, but this person can claim under nuisance, and we have the case of Dr. Boji Kanyerezi versus I think there was a school's girl he was suing and he successfully won. And then workshop 2 parts 3 shall form the moot. So basically here we shall be, it's a plaint for private nuisance, which we shall be doing within workshop 3. So basically that's what we are looking at as far as land transactions are concerned. They are very straightforward things, not hard, but we wish you success in your IA. I will remain the Pass the Bar team. If you need any consultations as far as the final exams, you can come and join us in a group where students pay a monthly subscription fee. And in case you have any sister or brother who is preparing for the LDC entry exam, I also have a department for that. Please have a blessed week and we wish you success in your IA. Reach us on 075 6767284. 075 6767284. You can just WhatsApp and we shall get back to you immediately.